So today we are thrilled to have Laura DiFrancesco. Am I saying that correctly, Laura?
DiFrancesco, Laura
DiFran-
DiFrancesco.
DiFrancesco. Such a lovely name. And
Thank you.
Karen Spencer here with us from Dean Street Law. Thank you for being with us, ladies. Been really looking forward to this session. If anyone is from new to Village Wealth, my name's Liz McCrae and I'm a co-founder here. And this was an older slide from another session we did last week from the sell side perspective. So today is not the sell side perspective, it is the buy side perspective. But you can tell how casual we are here, and we really encourage some jokes as well if you've got any hanging in the wings there. Village Wealth is a deal management platform. If you are new to learning about us, we are built for buyers on the buy side specifically. And we have a combination of tools on our platform from Marketplace integrated with our platform with over 50,000 listings. It's a unique functionality where M&A advisors can private message you. They can find you based on your search criteria. We have a deal management dashboard where early stage searchers, that's usually when they join us, when they're launching their search, can start to get organized in your deal management as you evaluate deals. And then we built in AI analysis, deal structuring calculators, and tools for you to understand how the financing works. As well, you can, if you're in the US, you can access new tech banks' pre-qualification process directly from within the platform. We partner very closely with ETA communities and incubators, lenders and investors and brokers and M&A advisors. So if you are one of those categories, we'd love to hear from you. Please don't be shy to reach out to us. And if anyone's new to the platform, we are offering a 2-week free trial when you get started with us in our premium subscription, which includes full access to the platform, notifications of new deals on a daily basis. We do weekly open office hours and full access to the deal management software. Feel free, if you haven't already, please feel free to introduce yourself in the chat. We'd love to know where people are coming from, and if you are a buyer or a seller or an advisor, it's helpful for our guests to know what lens you're coming from. And if there's anything that you also hope to get out of today, feel free to write that in the chat as well, so we know we're hitting all the boxes for you today. I'm going to welcome Laura and Karen to introduce yourselves today. And as Karen mentioned, please feel free to ask your questions as we go. This is a casual session, and we love some deep discussion and conversations here. So with that, I will stop sharing my screen and we'll get into your intros while Karen is going to pop up a presentation on her screen. But I will leave it to you both to take it from here.
Okay, wonderful. Thank you. I'm going to get this all set up. And Laura, I have two wonderful slides on you, but since you are here, maybe it might be best for you to start off. But let's do the topic first, which is avoid the potholes, a legal roadmap to a smoother closing. Today, we'll focus more on practical tips, things that really will help you out as a business buyer to be able to assess the business well and to close that deal and make that dream of business ownership come true. So I'm going to hand this over to Laura to talk about Dean Street Law and how amazing it is, and then how amazing she is as well.
Thank you, Karen. Dean Street Law, we founded 7 years ago. We just celebrated our 7-year anniversary. So we're very excited that in that time, we have closed over $10 billion of transactions. We do represent small businesses and Fortune 500 companies. Mergers and acquisitions is the majority of what we do. And we have myself as an attorney. Karen Spencer also helps us on deals as an attorney. And then we have a full team of legal assistants as well. We represent buyers and sellers, everything from entity selection and deal structure, LOI negotiations, all the way through closing and post-closing matters. So full service M&A law firm who is able to handle your deal making in the lower middle market. We're very excited to share with you today Karen's presentation. A little bit about myself. I've been an M&A attorney for well over a decade, working in big law for 7 or 8 years before starting Dean Street Law. And as an entrepreneur myself, I think like an entrepreneur and help advise entrepreneurs in acquiring businesses, scaling, growing, and ultimately selling their business. I have 5 businesses of my own, including Ethereal Farms, Flourish Co-working and Event Space, Laura DiFrancesco LLC, White Horse Investment Group, and a few others. I'm also currently serving as Villanova's entrepreneur in residence, advising Villanova aspiring entrepreneurs. So happy to share knowledge. It's one of the things that I am most passionate about.
Thank you, Laura. Yes, yes, and her entrepreneurial spirit really does shine through in all of the legal matters that I've worked with her on. Um, so I am Karen Spencer. You may know me as one of the co-founders of Search Funder. I have branched off from that, and I have two businesses that I consider entrepreneurial. One is Fetch Strategies, under which I do Vault and the ETA Launch Hub, and then Fetch Legal Strategies. And I've been working with Laura for about the past year, focused on buy and sell side SMB M&A. I think that my experience having coached and worked with searchers for a long time makes me a much better M&A attorney. And my experience in doing M&A makes me a much better coach for my entrepreneurs. So let's start getting into the heart of things. I always like to do the key takeaways first, just in case you have to leave at the last couple of moments. So, one of the things I think conceptually can be difficult for people starting out is that you've got one deal, but you're really running 5 different tracks or projects under that deal in order to get to close. And there's some key things that you need to do. I have a long list coming up in the presentation, but I wanted to highlight these few here, just for like that kernel or that nugget in your brain as you leave here today. Relationships and relationships. You protect that relationship with the seller to the extent that you have been engaged with them, and those of the key employees. It really will benefit you, not just at the close, but during the post-close period as well. Your goal early is going to be verify cash flow, and to the extent you can nail down that working capital, that can end up being not just a roadblock or a pothole on the road to close. We just did a session recently about how that can end up in legal disputes, and we want to avoid that as much as possible. Align your financing constraints early. I think people are doing a great job of that. If you're new to the space, this is for you. Make sure that you understand what your financing constraints are and how you can maneuver within those constraints to get the deal closed. And then when it comes to due diligence, you really want to put the major issues into buckets. The buckets are primarily fix it. Are you going to price it into the deal? Are you going to mitigate it? Or are you going to walk away from the deal? So just a simple rubric as you're going through the major issues. So let's talk about the 5 tracks. And they all run in parallel as you're trying to get the close, and there should be meeting on closing day into a good outcome. The first is the people track. Importantly, the trust the seller has in you to be able to close the deal and run the business, your trust in the seller that what they actually said that they do and own, they actually do and own, and key employee retention. The money track, everybody is usually very keenly focused on that. That's the economics of the deal, what the financing timeline looks like. And then there's the legal part, which we'll talk about in more detail here. it's not just the documents, but the diligence and the actual mechanics of getting everything closed on time. And then compliance, that's the regulatory piece. You have local, city, state, in the United States, federal regulatory regimes, and making sure that you understand how that interacts with the business. And then operational, like, can you run this business on day one? And what are the systems? What's the handoff going to be like? So that's the 5 tracks, and I'm going to try to highlight issues in each one. I will not read all of the slides because I will probably quickly get the hook from Liz that I've run over time. When I talk with early stage searchers, they're usually focused on mechanics like the CRM system, the deal financing, the spreadsheet. When I talk to searchers who have bought businesses, they're always focused on the people and, into a certain extent, how the people interact with the processes. And I cannot overemphasize enough the people track as you're thinking about getting to close. There's a few little tips here, like getting the full names of employees. You may not be able to get them early on, but as you get closer to close, make sure you have a list of who the employees are, particularly the key ones, and what their full names are. I know that sounds basic, but it does happen that you're like, no, which Bill is that, and which Jim is that, and which Madge is that, as you're going through. Then plan for retention. How are you going to work with the seller after the deal closes? Is it going to be a consulting arrangement? What does that look like? How long is that going to be? Is that going to tail off? What are the incentives? Another thing to think about on the people track is figuring out whether the seller has any key trips they're taking after close. So are they going to, the day after close, go on the Royal Caribbean around the world cruise and be completely unavailable for a month? What does that look like from a people perspective? Then on the money track, sometimes I do meet folks who think that the bank underwriting will catch everything, and it does not. The bank's concern is whether you're going to be able to pay back the note. Your concern is whether you're going to be able to run the business and grow it. And so you should be doing your own diligence in addition to the QOV and legal diligence that will happen as well. I wanted to point out here about working capital. If the seller is not sophisticated, has not done a deal before, has not interacted either on the finance or legal side, just keep explaining working capital. People have a tendency to nod like they understand. And then what they do is they go talk to their brother-in-law who may have had accounting in first year of college to explain what it is. So the more you can explain and really break it down for them, the more credibility you have, and then they can figure out whether their brother-in-law actually knows their stuff or does not know their stuff. I won't say anything about my own ex-brother-in-law at this time. I'll just keep moving on. And I titled this slide "Money Track Pit Stops and Stalls." These are areas where things can get stalled, and for quite a while. If there's some confusion about what's included or not included in the working capital, your deal can get stalled. So if you are looking at the business, talking with the seller, if you have the opportunity to do so, try to figure out or find out from them all of the sources of cash that's coming in. Do they occasionally do this sort of project that where they've got ongoing projects? So how are you going to allocate what gets paid and by whom during the deal close if the project's ongoing? Go ahead, Liz.
We said questions throughout, so I'm just
Yes,
gonna
please,
jump in
please.
here.
Yes, yes. I
So
don't like to talk that much, actually, so this helps. Yeah.
So a lot like we know the common definition of, working capital, assets less short-term assets, less short-term liabilities and that sort of thing. But do you have a way that you like to explain working capital, to a business owner if they've never heard? Like, do you have an acronym or another way that you like to describe it that might be a little bit easier for them to grasp?
I should come up with one. I think that would be wonderful. I'd like to think of it conceptually as what does it take to run the business on a day-to-day level, and what are the sources of cash that allow that to happen? And if I think about it on a day-to-day level, then I bring it out much more broadly into, are there seasonality issues, and is that going to impact the close of the business? And what that working capital looks like, right? If you have a seasonal business and you're closing at the peak, it might look very different than when you are closing at the nadir, right? Laura, do you have something that you'd like to add? Do you have a rubric that you use?
So ultimately, working capital is current assets less current liabilities, but specifically how that's defined is particularly negotiated within the transaction documents. Does that include inventory? Does it not? Are there some certain things on the books under current assets or current liabilities? There are add backs that should be excluded. So the definition itself is highly negotiated, but conceptually, I like to share it as it is the engine of the business. And imagine you're selling a car. If you have a car without an engine, it's valued at one value. If you have a car with an engine, it's valued at another. If you have a car with the most souped up engine you could possibly buy, it has another value. And so when someone can kind of think of something in a way that's not so jargon M&A, it's a lot easier for them to conceptualize how working capital itself is a function of value and how what you include in it ultimately determines the value of the business or influences the value of business.
Thank you. That's great. I've heard a car analogy before, but I've heard the car analogy in terms of, it's the gasoline in the car, and so you don't buy a car, brand new car, and then bring your jerry can to the dealership and fill it up, and there's some fuel
Yep,
already in it. So the engine, I like that one. I've never heard that one before.
that works too,
And
gas in the engine.
yeah, we have a question from Na, and please let me know if I say your name incorrectly.
You got it. You got it perfectly, Nah. I was wondering if you could go back one slide when you were talking about explaining the accounting to the seller,
Mhm.
especially a first-time seller.
Yeah.
Yeah, can you emphasize that point again and how
Yeah.
important it is and how to do it?
You, it's going to depend upon what type of seller you have, and also how do they learn things. But what you basically want to do is, I would say, almost like inoculate that seller against other interpretations. So my preference would be, if if you're in the same town or can go and talk to the seller, is to meet with them live, sit side by side, walk through how the accounting is going to look, make sure you're looking them in the eye, like, do you understand this or not? Where does it get fuzzy? I used to do this a lot with my clients, and then also with the opposing team on large company deals. You would be surprised about how quickly you can get a deal done when you can look somebody in the eye and really understand from their body language whether they're getting it or not, or if they're hesitant about something and just don't want to ask. So um, when I say explain, 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 I don't necessarily mean keep saying the same thing over and over again, but making sure that you're talking about it. I've heard of instances where searchers kind of talk about working capital at the LOI stage, and then a couple of months go by and they're not really talking to the seller, and then the working capital comes up, and then like Laura said, like, is inventory included or not? Is these types of work in progress included or not? And it can make a significant difference. And as sellers move through the process, they become much, much more detail oriented about the mechanics and what is the number that they're going to be landing on at close. Does that help now? Thank you. Yes, and please do keep questions coming. I'd much rather have a conversation. Let's see, on pit stops and stalls. One area that doesn't get highlighted often is on undocumented practices. And it depends if you've got a company that you're buying that's relatively buttoned up, they've got their systems and processes, that's fine. If it's if the gentleman or lady are still running it out of a shoebox, there may be side agreements. For instance, oh, when I sell the company, I'll give you, a bonus. Or one that I heard about was the seller promised that the buyer, when they bought the company, was going to give all of the employees bonuses, but the buyer didn't know. Things like that happen. So, when you're talking with the seller, if you have the opportunity to do so, trying to figure out how they run the business and then what are the big practices that they do. They may not even be thinking about them because they've done it for so long. So the legal track, is there a question? I see your name and an arrow, but I'm not sure if that's just a artifact.
I was just testing out its function on the side here. Apparently you
Oh,
can
okay.
write stuff and then
Oh,
I don't know how to erase it here.
right.
There you go.
Okay.
I successfully
Okay.
erased it.
Now I'm going to go back and figure out how that is done.
Yeah.
So on
See?
on the legal side, there are basically 10 different phases. So when you start with the LOI, you're only on phase 3. That is somewhat of the depressing news. The good news is that if you're working with a good attorney, they will help you move through the phases as quickly as possible. And again, I'm not going to read everything on the slide. We will be providing them later. I really like looking at the SMB M&A space. I cannot state enough how important getting a good quality LOI is to a smooth close. I was talking with one gentleman, and he's like, "Well, the LOI doesn't really matter. We'll just renegotiate everything anyway." And I felt like that is probably not the right approach to your LOI. And we'll talk a little bit more about that later. But getting a good quality one, having it reviewed by an attorney, if you really feel like this deal is going to go to the distance, maybe having the attorney look it over briefly before you set it out would be very important. So then what are the other phases? You're gonna head into due diligence, which is where we try to ascertain the does the seller actually own the business? Is this a business a going concern that is validly formed? You'll be in Q of E looking at the cash flow, the profit and loss statements, balance sheets. We also look at those as well, and other compliance documentation. Then you've got the principal and ancillary agreements, and then the preparation for closing. So this is a big immediate phase. The closing can go smooth or rough. It just depends on the deal and the nature of it and the speed of it. So hopefully it goes smooth based on these tips that I'm giving you today. And then you have the post-closing, and of course, you're running your business. And then hopefully, my favorite, expanding your business and growing it. So let's dive a little bit more deeply into the legal track on the LOI. A lot of times people think of the LOI as just kind of this form that they do. It does govern the process by which you close. It does govern the relationship between the parties. So if you think of it as a relationship document, it can be very helpful. So it will oftentimes prescribe what happens if either party decides to walk away before the close happens. Go ahead, Nat. Question?
Yes, I have a question. I was wondering if, for the purpose of whether the seller owns the business, like you mentioned, um, how does that occur in terms of validating that? So, using real estate example, when you buy a house and you want to figure out if the owner actually owns the house, the lawyer will run a title search, right? How does that work for a business?
Yeah, for business, we do look at what has been filed with the government, and we also look at what documentation they have. So if it is basically, if they got shares, do they have the right consents? Do they have the right board meetings? Do all of the numbers add up?
Okay, so so a lawyer has to be doing that, right?
I would have a lawyer look at that because it can get kind of tricky. Yes, I would definitely have a lawyer look at that.
Okay, so on that note, then, for buying a business, obviously case by case, there are lots of sizes involved in terms of the business transactions. Um, how does it work for small business transaction? So again, is it flat rate? Because some real estate deals are flat rate, or is it like hourly rate, or is it a contract base or fees percentage? Like how does it work for legal fees?
So it depends upon the attorney that you hire for it. At Dean Street Law, Laura likes to do flat fees, and I'm going to have her talk about it, and then I will probably add some extra spice on that too.
Sure, absolutely. So we ask questions about the transaction specifics, the target company, the deal terms, and that will define the scope of work. So in terms of chain of title, like you're talking about for real estate, there's similar chains of title for a company, for the assets it owns, et cetera. So how you transfer those assets will depend on the terms and structure and the target company itself. And based on all of those, we put together a plan to legally transfer the business, to incorporate the terms that you're looking for, and put together a scope of work with a flat fee and milestone-based payments. Of course, every company, every firm does it differently, so you always want to ask those about particular pricing with respect to a specific deal. And then we also have a question about insurance. Kareem had asked about thoughts on insurance, both rep and warranty insurance and insurance due diligence, and how effective is rep and warranty insurance, and is it worth the premiums? So we can either slot that in now or at a future time. I just wanted to flag that for you, Karen. Thank you so
So
much, Nat, for your question.
I'd like to hold that off for just a moment, and because we'll get to that, I think, when we get to the purchase agreement. And then Laura, I'd like your take on that question about whether it's worth it, and really at like what size business or risk level that you think about it at that point. So on the LOI, understand the dates and gates, basically understand the dates and what you need to do to move on to the next phase. I recommend calendaring those. We do that, and Laura's team is wonderful at reminding folks about these deadlines. But I think if you're managing the deal and managing the tracks, make sure that you know what your deadlines are and that you're moving towards them or getting the time extended as needed. So then let's talk about diligence. And thank you now for actually doing kind of a lovely segue on the diligence piece. We review every single document that comes into the data room to make sure that we understand the business, understand the impact on the legal terms of that document. When you complete diligence, the output should be a list of issues, particularly key issues to be addressed. And as I said, you can price it, fix it, mitigate it, or should you walk away? The one thing I would say about diligence is that if you have a highly skilled, dishonest person who is essentially a liar and a fraud, it's really, really hard to find even in diligence. I was talking with an investor in the search fund space in the United States, and their business they bought. They diligenced it. And typically the story goes something like this for most people, and this person's story was similar. But we kind of knew that, he was a little bit salesy. We kind of knew that like we couldn't completely trust him, but we thought we could diligence around it. And was running the business for about a year, and then we couldn't figure out why we weren't making the numbers that had been in the diligence. And then we discovered that the gentleman had essentially a computer in the back storage room that was just basically generating numbers and then putting it into the books.
Wow.
So, right, a huge lawsuit ensued. So I always recommend to folks that if you get a hint that the person is not trustworthy, it's very difficult for us, for any team, to be able to diligence completely around that. So the skilled, dishonest person is probably the hardest one. Laura, do you have a thought on that? Would you like to add?
Sure. I mean, I think a lot of people say, well, if it's in the contracts, it's solid. But ultimately, your gut and your radar for trusting someone is more important than what's in the contract because you then have to go and try to enforce the contract. And at that point that you're trying to enforce the contract, it's going to cost you at least 15 or $20,000 minimum to then get what you thought you were owed, but that's only the starting costs of your litigation. And then if you were to sue someone who has nothing to their name, they're not going to have anything to pay you in damages, so you won't be made whole. So, legal documents, legal diligence, legal documents are incredibly important. You can't legally transfer a business without them. With that said, they are belts and suspenders to trust because ultimately, if you have to rely on what your contract says, it's going to be an expensive road, and the person you're suing might not have the pockets for you to be made whole for the damages.
Yeah. And
Yeah, I think there's so much gut instinct and gut feeling in these transactions as well. And sometimes it takes more practice, I think, going through the motions to recognize that gut, but it's something that, you've got to pay attention to on both sides. So important in these.
yes, that's yes, on both sides, yes. So then what all of that diligence is leading up to is an executed purchase agreement. That agreement defines the price and the mechanics and how true ups are going to happen at post acquisition. It helps to allocate risk between the parties. And this is probably a good time to start talking about the insurance. Laura, if you would like.
Absolutely. So when you have representation and warranty insurance, it's you really have to determine what is it insuring you. And so representation and warranty insurance is just like any other type of insurance. It's going to insure you for very specific things, and it's not going to insure you for other things. And it's also going to have carve-outs about what it's not insuring you against. So most of the time in deals, we typically see that representation and warranty insurance doesn't make sense until $25 million plus for cost. I have heard that there's much less expensive solutions, but the likelihood is that they're tailoring then what is covered in that representation and warranty insurance. And so the reason the cost is less is because it's covering even less. So the reason why you see rep and warranty insurance at the higher dollar figure businesses, 25 million plus, is because at that point, you may not have a founder owner who is willing to stand behind the representations and warranties. And so it generally is used as a tool where they hire essentially, they're doing their legal due diligence, their financial due diligence, and then they hire an insurance company to do a further level of investigative due diligence. And so then when you have a founder, your founder is likely going to say, I can represent and warrant that this company is not materially in violation of law. For instance, we might have a parking ticket, but we're not doing tax fraud. When you get to a $25 million plus size company, you may not have someone who is willing to represent and warrant those material items, compliance with law, the fact that there's no conflict with other contracts, et cetera. There's fundamental reps and warranties, and then there's like the non-fundamental representations and warranties about the sufficiency and accuracy of financial statements, assets, employees, et cetera. And so when you get into the bigger companies, you may not have someone who's willing to stand behind those reps and warranties, and they may want to say, well, this is only to our knowledge and only to these certain people's knowledge. And so when you get into those really in-depth negotiations, then the parties are looking for a solution of someone to say that this is true, or they will stand behind these representations and warranties. And so then you have a company that says, well, we will do a sufficient amount of due diligence so that we can stand behind those representations and warranties, but they're only going to stand behind certain ones, and there will be carve-outs about what is covered and what is not. So long story short, representation and warranty insurance is just like any other insurance. It's going to cover very certain things and not cover other things. And it does have an expense. So it's just a cost benefit analysis, but you don't typically see it until the bigger deals when the reps and warranties become so heavily negotiated that they need like a third party solution. Karen, if you have anything else you'd like to add to that, happy to.
I think that covers it. I was hoping to see a thumbs up or a follow-up,
And then I saw there was a question on insurance due diligence. So you might also look at working with an insurance provider, or even having conversations with the seller's insurance provider to ask about sufficiency of insurance. We're always going to be looking at loss runs and claims made under those insurance policies. And then you might have conversations with other insurance brokers to see if the rates that are being paid are competitive, if the scope of the insurance is sufficient. So those are all things that may be in your due diligence as well. Part of those are legal due diligence, such as loss runs and reviewing claims, et cetera. And when you're talking about whether the insurance is sufficient and whether the scope or amount is sufficient, those would be conversations that you would have with either the insurance provider for the company that you're buying, or third parties, so that you can get a second opinion or third.
And at least in the United States, there are folks who will help you with that insurance diligence for free. Of course, their hope is that you will retain them post-close, but there are resources for that, because what you don't want to have happen is that in the year that you are buying the business, there is a major accident that happens, and now your premiums are going to double or triple, and you don't find out about it until after the close. And there's another question in the chat.
Non-compete.
non-competes. And I am going to make this more general because I am not a Canadian lawyer and every situation is specific. And I know people hate those wishy-washy answers that lawyers give, but in terms of non-competes, it depends on the scope. So is the non-compete for this town, this county, province, or state? Is the duration lengthy? Is it only a year? Is it a few years? Is it 10 years? How much is that going to impede the seller if for some reason after they get done with this year-round cruise and they want to do some other activity? What is the scope of the restriction on their activity? Is it just that specific business, or is it any business within that subject matter? So it really depends. Every non-compete is different. It is in many respects what you can negotiate with the seller, and then what is legally appropriate under the law of the jurisdiction that you are in.
I can add to that as well, being here in Canada, Karen, I've sometimes like to Karen's point too, is like the further that a buyer tries to enforce the non-compete, the less enforceable it is. And I welcome Laura's perspective on that too. But that's what we've seen in Canada is and the longer it is, harder to enforce. So typically what we see is that, the purchaser just wants to make sure that, when they take over that they have enough time to transfer all of the employees, but the clients and the services, and that they become known as the service or product provider, and that should you at some point go and start a competing business, that it's been far enough into the future that it's not going to impact the business that they purchased. So to Karen's point on some other questions, it depends, but it's a cost risk analysis as well in some cases.
Right.
Laura.
And on the, go ahead, Laura.
And then Daniel had asked from a seller's perspective, what are reasonable expectations? So reasonable expectations would be that it's of course sufficient to protect the buyer, but also that if the seller for some reason has a catastrophic event, that they're still able to make an income. And typically you're going to see some sort of ability to do that, whether it's that the location enables them to relocate and make a living, or that they're able to consult in the space to non-competitors. Let's say they consult downstream or upstream or in a sort of tangential way, in no way that's going to compete. So from a seller's perspective, it's reasonable to ask, okay, what happens if there's a catastrophic event and I need to make a living sooner than I expected to? How can I continue to making a living with the skill set that I've developed most of my life? So that's something that's reasonable to ask. And there also, of course, may be embedded in the negotiations that uh, certain actions may be with the buyer's consent, because at that point they're deciding this isn't competitive, even though, on a broad stroke, it could be we've decided this is fine or something like that. So that's a few considerations too that can be discussed.
And I want to add just on kind of the buyer side, think about non-competes in terms of the key employees. One of the early searchers, they bought an insurance company. They thought that the key employee was driving a lot of the business for that company, was locked in according to the seller. And right after the acquisition, that key employee left, went across the street, and started a competing insurance company. And it was a relatively small geographic area. So as you're thinking about employee retention, non-competes are just one factor to consider in that.
Great point. Thanks for that, Karen.
So let's move on to the next slide. Oops, I went back. Sorry. There you go. The compliance track, I've alluded to that in terms of permits and licenses, and depending upon the type of business, depending upon the regulatory regime, that can get a bit convoluted and complicated. So making sure that you understand what sort of regulatory regime you're working under for the type of business that you want to buy. The other places to think about are employment practices. Did the business owner classify folks as independent contractors in the United States who really should have been employees? Are there specific compliance issues? If you're buying, let's say, a machine shop or something like that, are there environmental issues? So, and we do look at all of the documentation that is provided in that regard and try to provide assistance, but being knowledgeable on the compliance track and what is needed before the close and what is needed after the close is important. We have a follow-up question in the chat, asking about what's reasonable to be asked to stay on through the transition as well. Yeah, yes. And thank you, Ron, for answering that. Yes, it depends on the complexity of business. It depends upon, and sometimes the reason why the seller is selling. If they have like a critical medical issue or a family member with a critical medical issue, they're trying to sell the business to spend time with that person. The handoff may be very different than somebody who wants to go on that Royal Caribbean cruise. There's so many different factors that play into it. I've heard of buyers who basically want the seller gone within 3 weeks. I've heard of buyers who basically want the seller on for 9 months or a year or more, and situations where the seller has actually stayed on because they didn't want to run the business, but they really liked and were really good at sales and knew that if they could free themselves up from operations, that they could sell, that they could really grow the business that way. So there's so many different factors that go into that, but I would say at least negotiate some time period of transition, whether that's being available by phone, or not, or something like that. So maybe they're not coming into the office, but they are available for you to ask questions. Because you definitely don't want to get a few months in and discover an issue that you weren't aware of and then have no recourse to getting it answered at all. So let's go to the operations track. That's really about, are you ready for day one? We look at all of the major contracts that the business owner has. If consent is required by the vendor or the landlord or anything like that. And it may seem rather mundane, but it does help with revenue continuity when you're talking about the contracts with customers as well and your suppliers. To the extent we try to start tracking those consents and the requirements early, what the timelines are, and then it sounds simple, but making sure that you've got the keys and the logins to all of the different software that the myriad of software that people might be using, particularly for bank and payroll and insurance, to get that swapped over. I really believe in planning. So I've put here having a day one plan, a week one plan, a 90-day plan is important. And then try to keep after close apprised of major issues. Sometimes what happens is you have a fire drill on the finance and accounting side, and you're really focused on that. And some other issue that was brought up during diligence, maybe not a major or deal killer issue, kind of gets left by the wayside. Try to keep track of those types of issues so that they don't necessarily grow in significance over time because of lack of attention. And then I generally get questions about working with attorneys, having been an attorney myself and hired attorneys in my other life and the parts of my career. I always try to hire attorneys that I think would do the kind of work that I could do if I were an expert in that subject. That's why I like working with Laura, because she's the kind of lawyer I would be if I were an expert in deal making. So that's one tip that I like to give people. Really think about that in terms of who's going to be managing the close. Sometimes you need a bulldog, sometimes you need that pit bull, and other times what you need is just a really, really fluffy schnauzer. So or golden retriever. Um, as you're working with your attorney, make sure that you're keeping them informed on any key developments or changes that are happening. I know that a lot of times the financial side is moving at a pretty fast clip and things are going back and forth, but try to keep your attorney apprised of those changes. As the deal gets closer and closer to close, try to meet more regularly. So early on in the LOI, you may be only meeting or talking to your attorney, once every couple of weeks. As things get more serious, make sure that you're engaging with your lawyer. And then make sure you understand what we're saying to you. I always breaks my heart when I think I explained something clearly, and then somebody didn't ask that clarifying question or ask me to explain it differently. And don't feel bashful about it, because this is a big financial decision, whether you're the seller or the buyer. So make sure that you understand everything that we're saying, and make sure you understand what's in the documents that you are signing. Go ahead now.
Yeah, you mentioned this earlier and just now to engage with your lawyer early when you're drafting the LOI.
Mhm.
Um, I heard that a lot of us draft a lot of LOI before we successfully go through with one transaction. And I heard that LOIs are not totally binding. So how early? That is not too early because considering it's flat rate, you probably don't want us to bring you 10 LOI to discuss. Do you? I don't know. I don't know how it works. Hence the question.
So I think, and I'm going to have Laura add on to this. I think that you should have I think you should assess the type of deals that you're doing. What is the likely LOI that you're going to have? Make sure you understand the terms and you're working with the attorney on that. And then as you get closer to submitting that LOI for the other side, have the attorney take one look over it, like one pass through. That can save you a lot of heartache later. It may be that, yes, this is a deal in this industry, but in this segment, this issue arises that if we put something in the LOI, it could help you out. Laura, do you want to add to that?
Sure. Just for clarity, there are certain sections of the LOI that are non-binding, and there are certain sections of the LOI that are binding. Ultimately, if you're putting any money on the line, if there's any sort of deposit, always have an attorney review it. It's all dependent on your comfort level and your experience in the space. If you're working in private equity and have been negotiating LOIs for years, I would say comfortably you can go off and probably do that because you have a firm understanding of what's binding, what's non-binding, how to negotiate those various terms. But I will say, if it depends on whether it's a competitive situation or a non-competitive situation, where you can align on economics, purchase price and general big terms, I do think it's worthwhile to then have conversation with an attorney if you're able to, because at that point you know that you're going to be more likely to succeed in that bidding process. And then you can make sure that the LOI is a good foundation for your entire transaction. If you're just sending out LOIs without having meaningful conversations with the seller about terms and how aligned you are, then yes, that is going to be a considerably more expensive process. And so you may do more of that on your own because it's less likely that is going to have each one is going to be as successful, right? And so that might be the situation where you submit more like 10 rather than if you're submitting an LOI after you're more aligned on, okay, we're more aligned on price range and, expectations, then you might only be submitting a handful. But it's certainly something that we keep in mind. And we do have a reduced flat fee for LOIs for that reason, because we understand that it's a process that buyers go through oftentimes more than once. We do have a question about the business that relies heavily on H-2B workers and whether there are legal or practical issues with visa continuity or employer liability that could complicate an asset purchase versus keeping the existing entity. We can address that, Karen, whenever you'd like. I just wanted to flag that.
Actually, this is probably a good time. I was just going through some additional resources, so this is probably a good time to address that. Yeah. And I will defer to you on answering that question.
Sure,
And we've
absolutely.
got just a few minutes left before the bottom of the hour here, ladies.
Thank you. So for those visa programs, and they're all where you have a specific company that has petitioned for a particular um, approvals, registrations, and everything like that. And those cannot easily be transferred to another business. There can be an amendment to a petition if there's an asset purchase, but ultimately that creates a lot of challenge. Most of the time, you'll want to do an equity purchase in a business such as that because getting those approvals and petitions and registrations all completed can both pose a timing issue as well as an approval issue. So continuity, most of the time you'd want a equity purchase there instead of an asset purchase. But then, of course, it's going to make your indemnification even more important and potentially also having an escrow so that you can have a an ability to have recourse in the event that there's successor liability for past wrongdoing with respect to that specific compliance risk.
Thank you, Laura. I'm gonna just review quickly before the end of the hour all of the wonderful, amazing resources you have, and then now we will get to your question. Then Laura has a ton of great resources on her website and guides. She also has Acquisition Insights, a legal roadmap for success, a training program with various modules that you work through. It must have been a labor of love to have done it because I know how much hard work it is. And she provides different options, a standalone course, the course with templates, and then the full package. Would you like to add on that about that resource, Laura?
Yeah, absolutely. So we have our free LOI Masterclass, which you can sign up for. This QR code links you to all of our resources. We have free guides and that free masterclass. Then we also have Acquisition Insights, which is a full course. You can also purchase all of our battle-tested templates, such as LOI, closing checklist, etc. And we also have a book, Entrepreneurship Through Acquisition, a legal guide to buying a small business on the sell side. And buy side, we have a podcast as well with lots of different topics. So feel free to explore. You can connect with us on LinkedIn. We'd love to connect with you on LinkedIn, Search Funder, etc. So please feel free to reach out if you need anything.
Thank you both so much. And oh, you've got a few more takeaways there, Karen. I'll let you wrap
Yeah,
up.
it's the same takeaways at the beginning and the end, so we are fine. I wanted to put up the Let's Connect slide.
Thank you, Karen. And if you'd like to schedule a consultation call, that's also through our website, deanstreetlaw.com.
Thank you, Laura. Thank you, Karen. For anyone that does need to leave, thank you so much for joining us. And Karen, Laura, do you have a few minutes extra to stay to answer Na's last question there?
Yeah. Oh, yes, certainly.
Fantastic.
Thank you so much for taking the last question past the hour. For budget purposes, for myself at least, I'm selfish in my questions. Are you able to share a range of what I should budget for a small transaction, assuming it's a smooth, and no complication for
Yeah.
purchase for buying?
Ours are more built on scope of work. I think a lot of people think like a smooth transaction means a certain thing, but really it's like, is the seller one entity? Is it three entities? Do they have one location? Do they have three locations? Are you fundraising or are you getting an SBA loan? So all of those will determine what the scope of work is. But generally, what we see on just the acquisition, buying a business, not fundraising or whatnot. If you're looking at the $3 to $5 million range, you're generally looking at 25,000 plus or minus, depending on complexity. If it's a remote business with no leases, then that's less. If it's one with three leases that we need to renegotiate, that would be more, just by example.
Great, thank you. The example is helpful.
Yeah, absolutely.
Any
Thank you.
other questions while we have I have just a few more moments. Go ahead and stop the share.
We can see everyone.
Yeah. Well, thank you everyone for being here. This was like the fastest hour I've had in quite a while. It was very fun. I really appreciate your questions. It's definitely not selfish. It's prudent to get your questions answered. So I hope you return again for one other sessions.
Fantastic. Well, we'd love to have you ladies back, and that's a wrap for our Friday sessions. So
Yeah.
everyone, have a great weekend, and thank you for putting your contact information, ladies, for these folks to be able to reach out to you if they need to. All right.
Thank
Take
you.
care,
Thank you,
everyone.
guys.
Happy
Thank you.
Friday. Have a great
Happy
weekend.
Friday. Okay.
Take
Bye.
care.
Bye, everyone.